I have seen people spend 30 years paying off a house and then lose sleep over the wrong threat. They worry about the roof, the furnace, the driveway, the property line, the market value, the neighbor S-tree, and the next storm season. They do not worry about a forged deed, a judgment lien, an IRS notice left unopened on the kitchen counter, or a tax delinquency letter that looks like junk mail until the county is already counting down towards seizure. That is a mistake. If you are over 60 and you own your home, especially if that home is paid off, you are not sitting inside a fortress. You are sitting inside a vault that is visible from the street. Anyone who knows how to search public records can see the equity. They can see whether there is a lender attached, they can guess your age, guess your habits, and guess that nobody ever taught you which papers stand between a lifetime of work and a very ugly surprise. I want to say something plainly because plain language saves more wealth than polite language ever will. A paid home is not safety by itself. A paid off home without the right documents is concentrated wealth with weak locks. People hear a phrase like home ownership and they imagine permanence. I hear a phrase like that and I immediately ask a different question. What protects the title? What protects the equity? What protects the transfer? What protects the owner from the paperwork that arrives late, looks harmless, or never gets opened until the damage is already done? That is how I think about risk. I do not begin with comfort. I begin with a chain of events that can break comfort in the stock market. I have always preferred businesses that make my downside narrow before they make my upside large. In real life, your home deserves the same treatment. Before you worry about appreciation, remodeling, or what the house will be worth in 5 years, you should make sure the paperwork around it is not full of open doors. Most older homeowners do not lose wealth because they were reckless in some spectacular way. They lose wealth because the system around them is built on forms, filing deadlines, public records, lien priority, probate procedure, and tax rules that nobody explains in one place. It is death by administrative ambush. I have seen the pattern enough times that I can name it. The first mechanism is what I call the visibility trap. Your house sits in public records like a fully lit display case. The title is searchable, the address is searchable, the ownership is searchable. If there is no mortgage on it, that is a signal. If the owner appears older and the property is free and clear, that is another signal to a criminal, to an aggressive creditor, or to a county bureaucracy that never misses a filing deadline. This is not a warm family home. It is clean equity. The second mechanism is what I call the silence gap. The government and the local offices often have the information they need to help you, and yet they do not proactively tell you about the tools that would reduce your risk. The county knows you own the property. The county knows there may be a fraud alert program. The assessor knows senior exemptions exist. The recorder knows homestead forms exist in many states. Nobody knocks on your door and says, "You are now the ideal target. Here is the checklist." The third mechanism is what I call the paper lag. Trouble almost always arrives on paper first. A notice, a bill, a lien filing, a delinquency warning, a probate issue, a forged deed entered into a county record. The person who wins is not necessarily the one with the best intentions. It is the one whose paperwork got filed first, flagged first, or challenged first. If you want to protect a paid off home after 60. You have to stop thinking like a homeowner and start thinking like the manager of a small private fortress whose gates are made of county filings and tax forms. That sounds less romantic than talking about retirement. But romance never protected title. I want to walk you through the 5 documents and protections I would treat as non-negotiable. If I were sitting in your living room and that house represented a huge share of everything I had spent my life building, I am going to do it in the order I would think about them. I would begin with the document that most people have never filed and which, in the right state, can protect a shocking amount of equity from ordinary creditors. That is the Homestead Declaration. The genius of this document is not that it makes you richer. The genius is that it redraws the line between your home and the people trying to reach into it. When filed properly, it can protect a specified amount of equity in your primary residence from many unsecured creditors. Not all, not the mortgage lender, not the IRS if federal tax liens are involved. But many of the people who show up after a lawsuit, a personal debt, a medical collection problem, or a judgment. Those people care a great deal about reachable equity. Your job is to make as much of that equity unreachable as state law allows before they ever come looking. This is one of those facts that separates sophisticated families from everybody else. Sophisticated families do not wait until after a judgment appears to learn the rulebook. They file the protection first. The exact value depends on the state, and that matters enormously. In some places, the protection is so powerful it changes the entire risk profile of homeownership. In others, it is smaller, but still worth having. Some states protect very large amounts of equity. Some offer different levels depending on age or county housing values. Some give retirees a powerful version they have never bothered to claim. A person who knows none of this can sit on hundreds of thousands of dollars in home equity and assume the mere fact of ownership protects them. It does not. Law protects them if they invoke it. That difference is the whole game. People ask me why wealthy families often seem calm in situations that terrify everyone else. The reason is not courage, it is structure. They have already put the boring documents in place. If I owned a paid-off house and I had not filed a homestead declaration where one is available, I would treat that as an unforced error. It is the kind of mistake you only make when nobody ever explained that the law does not protect what you never formally claimed. This is also where I want to inject a dose of realism, because realism is worth more than reassurance. The Homestead Declaration is not a magic cloak. It does not stop mortgage foreclosure if you default on the mortgage. It does not overrule a federal tax lien. It does not stop every species of legal claim. That is exactly why honest explanations matter. The right paper is powerful. The wrong expectations are dangerous. If you want a simple way to think about it, the Homestead Declaration is a wall against many ordinary creditors. It is not a wall against every sovereign force in the system. It is part of the shield, not the whole shield. The second piece I would put in place is the one that addresses the speed problem. If somebody records something fraudulent against your property and you only find out months later, you are no longer in prevention mode. You are in damage control mode. Prevention is cheap. Damage control is legal. Fee expensive. That brings me to the property fraud alert. I regard this as one of the most absurdly underused protections in the country. In many counties, you can register for a free alert that notifies you when something gets recorded against your property, a deed, a lien, a transfer. Some change you did not authorize. It can be the difference between discovering fraud in a day and discovering it after the scammer has already borrowed against your house, transferred title, or set off a chain of paperwork that now requires lawyers to unwind. The reason this matters so much to retirees is brutally simple. A free and clear house attracts the wrong kind of attention. There is no bank sitting in the chain as a vigilant lien holder. There is no lender with its own separate monitoring motive. There is often an older owner who assumes that because no sale is happening, nothing is happening. That assumption is gold to a fraudster. The fraud alert closes the silence gap. It does not stop someone from trying. It stops you from remaining blind while they try. That distinction matters. In the investing world, speed of information often determines whether a problem becomes inconvenience or catastrophe. A property fraud alert gives you time, and time is the raw material from which defense is made. When you learn about a fraudulent filing within 24 hours, you can call, flag, challenge, and escalate. When you learn about it after a refinance was attempted or a fraudulent transfer rippled into later paperwork, the cost multiplies. If your county offers that alert, and many do, there is almost no excuse not to sign up. It is one of the rare protections in life that is fast, free, and directly tied to an obvious threat. Now I want to make an important pivot because many discussions of home protection become unserious right here. They talk about scams, they talk about shady creditors, they talk about paperwork at the Recorder's office, then they glide past the largest and most powerful collector in the room as though it does not exist, the IRS exists, and when the IRS arrives, state-level comfort can disappear very quickly. I want to be very plain about the hierarchy here. A federal tax lien does not care that you filed a homestead declaration under state law. Federal claims can override those protections. If you fall behind on taxes, ignore notices, miss payments, or create a tax issue you do not promptly address, you can discover the hard way that the neat little wall you built against ordinary creditors was never designed to stop the federal government. That ain't a cause for panic, it is cause for discipline. A surprising number of retirees stumble into tax trouble not because they are dishonest, but because the sources of income change faster than their withholding habits changed. A distribution, a Roth conversion, a side sale, a large withdrawal, a benefits payment, a shift from wages to other forms of income, a notice gets mailed, it sits unopened, the person assumes they will deal with it later. Later becomes lien territory. My rule is simple, never let tax ambiguity sit. Open every IRS letter, every one. If you owe, resolve quickly. If you cannot pay, get into an installment agreement before the matter escalates. The difference between an ignored letter and a managed payment plan is the difference between a problem and a cascade. This is not a sexy topic. It is a rich topic, because nothing destroys peace faster than a home that feels paid off but is quietly carrying public tax problems against it. Now we come to the third document, and it addresses a very human misunderstanding. Many people think they already have title insurance. so they assume the title problem is solved for life. It is not. Most standard title insurance policies are backward-looking. They protect against defects that existed before closing. They do not automatically reach forward and cover the future fraud that happens years after you bought the house. That is a different risk. That is why the distinction between standard and enhanced title insurance matters. I would call this the rear view mirror problem. People assume that because they bought insurance at closing, the windshield is covered too. Often it is not. An enhanced owner's policy can cover things a standard policy often will not, including some kinds of post-closing forgery, fraudulent deed activity, or identity-based title attacks, along with legal fees associated with fighting them. If you have ever seen what legal fees look like when a simple property dispute turns into an ownership contest, you stop treating this as an abstract subject very quickly. This protection is not free. It is not a county form. It usually means calling the title company, understanding what policy you have, and asking what it would cost to upgrade if you only have the standard version. That single conversation can tell you whether you are protected against history or protected against the future. Those are very different things. I would never assume I have protection I have not specifically confirmed. That applies to investing, it applies to contracts, it applies to estate planning, it applies to home title. A vague memory from closing day is not risk management. The fourth document is one I consider essential, not because it fights every creditor during your lifetime, but because it changes the public exposure and transfer mechanics of the house in ways that become more valuable as you get older. That is the Revocable Living Trust. I want to explain what this does in the plainest terms possible. A properly drafted and funded Revocable Living Trust can hold title to the home. You still control it, you still live there, you still decide what happens, but instead of the house sitting directly in your personal name in the most obvious way, it sits under the trust structure that does not make you invisible. It does make you less simple to profile and less easy to process through the fastest scammer workflow, which is often built around quick public record searches and obvious human owners. More importantly, the trust helps the house bypass probate when you die. And probate is where time, money, and publicity gather like crows. I do not like unnecessary court process. I do not like public process around private family property. I do not like delay when a surviving spouse or children are already dealing with grief. I do not like extra fees attached to transfer when structure could have reduced them. Probate offers all of those things if you have done nothing. A living trust is one of the cleanest ways to reduce that mess. I need to draw a sharp line here because loose thinking creates expensive misunderstandings. A revocable living trust is not the same thing as creditor protection during your lifetime. It is not the same thing as the Homestead Declaration. Those two serve different masters. One helps with privacy, transfer efficiency, probate avoidance, and estate structure. The other helps shield equity from many unsecured creditors. You do not pick one instead of the other as though they are rivals. You understand the job of each and you use both where appropriate. That is how serious people think. And there is a second trap here. Some people already have a trust document sitting in a drawer somewhere and think the work is done. The work is not done if the house was never actually transferred into the trust. The trust only governs what is in the trust paperwork that exists in theory, but was never funded with the deed, is just optimism in a folder. I have seen that error enough times to say it without sugarcoating it. A trust you never funded is like a safe you never put money into. It makes you feel organized without changing the outcome. For many families, this is also where state-level inheritance or estate issues come into view. Federal exemption thresholds may be large, but states have their own rules, their own thresholds, and their own appetites. A good trust combined with sensible estate planning can reduce cost, reduce delay, reduce public exposure, and in some cases reduce taxes your heirs never needed to pay in the first place. That is not theory. That is implementation. Now I come to the fifth protection, and it is the one older homeowners underestimate until they discover the county moves with astonishing speed when tax deadlines are missed. I think of this as the redemption window problem. Here is the uncomfortable truth. For many people, the home is lost, not because the underlying debt was enormous, but because the timeline was not understood. A delinquency notice sits unopened. A medical issue distracts someone. A spouse dies. The household routines break down. Property taxes slip, penalties grow. Then the government process starts moving in a lane most ordinary people do not track until it is nearly over. You must know your state and county timelines for property tax delinquency, redemption rights, and forfeiture procedure. You must know them before you need them. I want to stress something else because it is one of the clearest examples of why legal victories do not instantly solve administrative reality. Courts may say a county cannot keep more than what is owed when property is seized and sold for delinquent taxes, that principle matters, but the existence of a principle does not remove the deadlines that still apply. It does not stop the stress. It does not stop the sale process from beginning. It does not guarantee every local implementation is fast, clean, and homeowner friendly. What saves you in practice is not merely knowing the Supreme Court said something fair. What saves you is not letting the process get that far in the first place. This is where the tax redemption record mindset comes in. You watch every delinquency notice. You know your deadlines. You do not ignore county mail. You do not assume the issue is small because the initial amount is small. In real estate, a small bill can become a giant lever if the process around it is ignored. And here is the extra layer many older homeowners miss entirely. Many states and counties offer senior property tax homestead exemptions or assessment freezes that can reduce the annual bill materially. They are not always automatic. You often must apply. That means many retirees have been overpaying for years simply because nobody told them a form existed. This is one of my favorite categories of financial negligence. Not because it is amusing, but because it is so fixable. People will spend hours clipping coupons, switching insurance carriers, or debating which savings account pays 30 basis points more, and then fail to file a senior exemption that changes their property tax burden every single year. That is not frugality. That is majoring in pebbles while stepping over bricks of cash. If you are over 60 and you own your home, you should know with certainty whether your county or state offers age-based homestead exemptions, freezes, deferrals, or valuation reductions. You should know whether you have applied. You should know what deadline governs the current year. The words, "I assumed it happened automatically," are expensive words. Now step back and look at the full architecture. The Homestead Declaration is the creditor wall. The property fraud alert is the early warning alarm. Enhanced title insurance is the forward-facing litigation shield. The Revocable Living Trust is the privacy and transfer engine. The tax redemption and senior exemption file is the defense against county process, overpayment, and deadline blindness. That is not 5 random documents. That is a perimeter. Most people go through life thinking home protection means paying the mortgage on time and maybe carrying homeowner's insurance. That is beginner level thinking. Those things matter, but they do not solve the deeper problem. The deeper problem is that your house sits inside overlapping systems of private claims, public claims, title records, tax procedures, estate laws, and fraud opportunities. You cannot wish that web away. You can only fortify your side of it. This is where I want to turn the discussion from mechanics to identity, because real change happens when identity changes. For years, many homeowners behave like sentimental occupants. They see the house as the place where the family happened, the place where Christmas happened, the place where grief happened, the place where the dog is buried in memory, if not, in fact, all of that is emotionally true. But if you stop there, you are emotionally attached and administratively exposed. You need to become something else. You need to become the custodian of a protected asset. That is an identity shift. A sentimental occupant says, "I own my home, so I am safe." A custodian says, "I own a visible block of equity sitting inside legal and administrative systems, so I will harden the perimeter." A sentimental occupant assumes paperwork and wait. A custodian assumes paperwork is the moat. A sentimental occupant says, "I'll deal with it if something happens." A custodian says, "By the time something happens, the cheap stage is already over." That shift matters more than any individual form because it changes whether this becomes a one-afternoon project or another topic you nod at and postpone until the exact moment postponement becomes expensive. I have lived long enough to know that most ruin does not announce itself with trumpets. It arrives disguised as a small chore, a call you did not make, a form you did not file, a notice you did not open, a trust you never funded, an exemption you never applied for, an alert you never signed up for because nobody stressed how fast theft can now move through a recorder's office. People imagine catastrophe as drama. Usually it is administration. That is why I like checklists. Checklists turn drama into sequence. Sequence is manageable. If I were helping you build the operating system for this house, the protocol would be very simple. First, I would verify the homestead rules in your state and county and file the declaration if it exists and applies. I would not confuse that with universal protection. I would understand what it covers and what it does not. Second, I would sign up for property fraud alerts the same day. Not next week, not after lunch, the same day. Third, I would pull out my title policy and determine whether I have standard coverage or enhanced coverage. If I do not know, I would call. If an upgrade is available and sensible, I would price it. Fourth, I would examine whether a revocable living trust is already in place, whether it is appropriate, and whether the deed is actually titled into the trust, not hoped into the trust. Titled into the trust. Fifth, I would verify property tax status, understand redemption timelines, check for delinquency, and apply for every senior exemption or homestead related reduction available to me at the same time. I would review whether I have any unresolved federal or state tax issues that could create liens. Because pretending the IRS is a side character in this story is nonsense. That is one afternoon of work with maybe a few follow-up calls and perhaps a meeting with a professional where needed one afternoon. Think about the absurdity of that. People will spend more time deciding where to eat on a weekend than deciding whether the largest pool of equity in their life sits behind the right legal barriers. When I was younger, I learned that wealth is not merely what you earn. Wealth is what survives contact with reality: houses, portfolios, businesses, cash reserves, land. All of it means less than people think if the owner never learns the procedural side of defense. There's another reason I care about this subject. Older Americans are often targeted not because they are careless people, but because they are trusting people. They grew up in an era where a filed deed felt official, where a letter from the government felt legible, where a local office felt somewhat human, where fraud moved slower, where fewer things happened through automated databases and silent digital searches. The world changed, the habits often did not. You do not correct that by becoming paranoid. You correct it by becoming structured. Structure beats paranoia. Paranoia makes you anxious without making you safer. Structure makes you safer without requiring anxiety. And there is one more harsh truth worth saying. If you own your home free and clear, you may be the wealthiest person on your block in the only way that matters to predators. Not by income, not by visible spending, by trapped equity. The person with a paid-off house and weak paperwork is often a better target than the person with a bigger lifestyle and a giant mortgage still hanging over the property. That is why I dislike the phrase, "I paid off the house, so I am finally done." Number, you completed the financing stage. Now you must complete the protection stage. That does not mean you live in fear. It means you respect what you built enough to ring it with paper. I want you to imagine two homeowners of the same age on the same street. The first one tells me proudly that the mortgage is gone. The house is theirs. They have no alerts, no trust, no filed homestead protection, no understanding of title coverage, no idea whether they qualify for senior exemptions, and a stack of unopened county mail on the dining table because it's usually nothing. The second one says the mortgage is gone too. They filed the homestead declaration. They signed up for alerts. They checked title coverage. Their trust is funded. Their tax status is current. Their senior exemptions are on file. They know who to call if something lands in the mailbox that smells wrong. Which homeowner is actually secure? That is the question. Security is not a feeling. Security is a file. And this is where I want to leave you with the final test, because endings should do more than summarize. They should force a decision. If a stranger walked into the public record system tomorrow and searched your address, then searched your name, then looked at your age, then looked at whether the house sits free and clear, would the next thing they meet be a paper shield or a paper vacuum? If a judgment arrived, if a forged deed was filed, if a tax bill was missed, if a spouse died and transfer had to happen, if your children had to step in, would your house behave like a defended asset or a loose pile of equity waiting for smarter paperwork to outrun you? That is not a legal question. That is a character question. You spent decades paying for the house. Now ask yourself whether you have spent one serious afternoon protecting it, because if you have not, then the threat is not out there. The threat is the gap between what you think ownership means and what ownership actually requires. A house paid off without protection is not peace. It is delayed exposure. And if I were in your shoes, I would not go to bed tonight telling myself I will get around to this someday. I would make a quiet contract with my future self. I would say that before another week passes, the house gets its paper shield, not because I am afraid, because I am finally acting like the custodian of something worth defending.